Yes. Yes. Without getting the approval of the board of directors. No approval given by the board of directors. Therefore, this secretary has no, yes, list of authority.
Apparent authority.
Without getting approval. No, no. Not without getting authority means no express. Express means like the authority of the agent in writing, no orally. ලිඛිත වාචික හරි කියලා නැහැ. ඒතර මේ අධ්‍යක්ෂක මණ්ඩලය කියලා නැහැ. No actual authority. No actual authority. Like need not to have actual authority in order to form a binding contract between the company and the third party. Right. So here question it says, right, without getting authority means no actual authority. No actual authority given to the agent. Right? Sorry, no actual authority given to the JSP or the secretary, right? And in one hand, he's the agent, right? Oh, yes. But we can say secretary. No actual authority given to the secretary. Then here it says, without getting approval of the board of directors of the company, right? To hire 2 cars for the members of the board of directors. To hire, yes, to hire 2 cars for the members of the board of directors. To borrow 100,000 rupees, no, sorry, 1 million rupees, yes, sorry, 100,000 rupees for purchasing furniture to the boardroom of the company. Required to explain the legality of these transactions, right? So we have to know apparent authority, but we have to consider whether the secretary has apparent authority. Apparent authority. Then we can say binding contract formed between third party and company. If the agent has apparent authority which are of purely administrative nature. Understood? Shall we, first, this first question. The secretary of the company has apparent authority for the activities which are purely administrative nature. Required to explain the above statement. Right. Shall we take down an answer for the first one?
Okay.
Okay. All right. We can mention like this, right? Yes, we can mention, right? The secretary, yes, the secretary of the company, the secretary of the company is treated as an agent of the company. An agent of the company. Right. Then next line we can say an agent may have we have following types of authorities. Following types of authorities. Right. Number one. Actual authority. Actual authority. Right. And that we can say actual authority. It means the authority to the agent in writing or
Excuse me, sir. The authority
in
to
writing. Yes. Authority to the agent. Yes. Authority to the agent, right? Agent in writing. In writing, right? Comma, orally, or impliedly. Impliedly. That is the meaning of actual authority, right? Then we can move to next slide. Number two. The second type of authority is, right, apparent authority. Apparent authority, right? So, to whom it is apparent, third party, right? Third party. So that is the meaning of apparent authority, right? So under that we can say here, here, the agent has no actual authority. Agent has no actual authority. However, because of the status, holds by the agent,
because of the status.
right, by the agent, it appears to, because of the status, holds, 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 Dharana, holds by the agent, holds by the agent, holds by the agent, right, comma, it appears to third party, that the agent can, that the agent can engage into particular contract. Engage into particular contract. Particular contract. So that is the apparent authority. It appears to third party. Okay? Right. Now, the next line we can say according to the we can mention these two cases, right? Barnett and Company Limited. BARNETT. Barnett and Company Limited. According to Barnett and Company Limited. Right? One name is enough, right? According to Barnett and Company Limited. Court held according to Barnett and Company Limited case, right? We have to mention case. Sorry, case. Court held that the secretary of the company has no apparent authority to bind the company in contracts with third party. To bind the company in contracts with third party. Right. Next line we can say, however, in Panorama Development's case, Panorama Development's case, court held that the secretary is the chief administrative officer. Chief Administrative Officer, CAO. Chief Administrative Officer of the company. Right? Of the company. Then next slide. Therefore, The third party, therefore the third party therefore the third party is entitled to be to believe that he can engage into contracts. He can engage into contracts. He can engage into contracts on behalf of the company which are of purely administrative nature. Purely administrative nature. Purely administrative nature. Right, so you have required to explain the above statement. I think that is sufficient. No? Purely administrative nature. Right. So apparent authority recognized under this second case. Right. Then when we shall we consider the second question? Yes, me. Entered into contract on behalf of the company without getting the approval of the board. It is no altogether we can say no actual authority over to the secretary engage into these contracts, right? Of the company to hire to ask for the members of the board of directors. Now we can identify the first transaction is it is of administrative nature transaction. Therefore, we can say even though the secretary has no actual authority, right? He has or she, it should be she has uh, apparent authority, right? Apparent authority to engage into this contract with third party. Therefore, actually binding contract formed between Agro Company Limited and third party. But when we consider the second transaction that is not of administrative nature purpose, right? That is borrow 100,000 rupees for purchasing furniture to the boardroom of the company. But even though they are purchasing furniture, that is, he has or she has taken a loan, right? She has no apparent authority to borrow money on behalf of the company, right? So that is borrowing agreement, right? That is why we have to mention that she has no apparent authority to apparent authority to engage into this transaction, right? This is borrowing money. Reason is purchasing furniture. Purchasing furniture is administrative nature purpose, but cannot borrow money on behalf of the company. Therefore, we can say actually uh, for the second transaction, she has no apparent authority, then the company is not responsible with the borrower. Then who is responsible? If the company is not responsible, then who is responsible for the money borrowed by the this secretary? Just wait. Yes, who is responsible? Yasmin, right? Herself responsible for the money borrow, right? So if express authority, sorry, if uh, actual authority or implied authority is not available with the agent, then no binding contract formed between principal and the third party. No contract means who is responsible. The person who engaged into contract with the third party is personally responsible. Therefore, right, the secretary is personally responsible to the third party because she has engaged into contract to borrow money, right? So personally responsible, secretary personally responsible, right? So if there's no responsibility of the company, then maybe the person who engaged into contract is personally responsible, right? So explain the legality of these transactions, right? Shall we take down the first part, right? To, to hire two cars for the members of the board of directors. I can say before, come to that we have to little bit measure like this, right? Now, yes, shall we measure like this, right? First line, we can say according to the given case, right? According to the given case, the secretary had engaged into two contracts without getting the approval of the company. Without getting the approval of the company. Right? The next line we can say it means the secretary has no actual authority the secretary has no actual authority to engage into these transactions on behalf of the company. On behalf of the company. Has no actual authority to engage into these transactions on behalf of the company. No actual authority, yes, no actual, because without having the approval. Then we have to see whether the secretary has the apparent authority. Apparent authority means it appears to third party, whether it appears to third party that this secretary can engage into this type of transaction. Right? So under apparent authority, the binding contract formed between the company and the third party. Right? Understood. Right. Then uh, no apparent authority. Sorry, no actual authority. Right. Then we can say, next line we can say, the secretary of the company is treated as is treated as the chief administrative officer. chief administrative officer in the company. Chief administrative officer of the company. Right. Next time we can say, therefore, she has apparent authority. She has apparent authority. Apparent authority to into contracts. Engage into contracts on behalf of the company on behalf of the company which are of purely administrative nature. Purely administrative nature. Purely administrative nature. Contracts which are of purely administrative nature. Then next line we can mention the authority. That is the name of the case, right? In which case this concept is revealed, right? Panorama Developments, right? Versus Fidel Company Limited, right? So next line we can say example, e.g., right? Example, Panorama Developments versus Fidel Fabric Company Limited. Right? Just mention the name of the case. That is enough. Understood? Right. So now we have considered all the right the legal facts with regard to the status of the secretary. Then we can answer to answer to these two transactions. Right. Then next line we can say according to the first transaction. It is of purely administrative nature. It is purely, it is of purely administrative nature transaction. It is of purely administrative nature transaction. Right. Then next line we can say, therefore, a binding contract a binding contract binding contract will be formed by this transaction between the company and the third party. between the company and the third party. Right. Then next slide, we can say, right? According to the second transaction, she had engaged into a contract. She had engaged into a contract to borrow money on behalf of the company. The purpose is given here in order to mislead you, right? Don't be misled, right? The purpose is for purchasing furniture. It doesn't matter. Only thing is engaging to borrow money on behalf of the company. Borrowing transaction, right? To borrow on behalf of money on behalf of the company. Right. The next slide we can say, right? Therefore, it cannot be treated as an administrative nature transaction or administrative nature contract, whatever, right? Cannot be treated as an administrative nature transaction. Right? Then next slide we can say, therefore, there is no binding contract. There is no binding contract formed between the company and third party. Formed between the company and third party. Company and third party. Right. The next time we can say, therefore, the secretary has to personally responsible for this transaction. So that is the legality of these transactions. Right. Is it clear? Any question? Now we can ask. මොනවාරි ප්‍රශ්න තියෙනවා අහන්න පුතා. Yes. Any question? right? So legality of the secretaries like this, right? So consider under two categories: actual authority and apparent authority or ostensible authority. Because of the chief administrative officer of the company, uh, third party is entitled to believe that secretary can get into contracts which are of purely administrative nature uh, on behalf of the company. Then binding contract form between company and the third party. If there is no actual authority, no apparent authority, then personally secretary responsible for the transactions with the third party. So that is the concept that we have recognized here, right? So we have discussed about the how secretary will be appointed and qualifications, removals, right? Qualifications, then functions by the secretary, and the legal position of the secretary. So under that, we have to consider about two things actually and apparent authority. Is it clear? Anisha?
Yes, sir.
Okay. Prashna? Yes. Okay, then at that point we can stop for today. Right, so entire topic we have discussed and two questions considered. Right, if no questions, then we can stop. Okay, thank you very much.